Welcome to Infringe at Your Own Risk.
Hello, everyone, and welcome to Infringe at Your Own Risk with Rand Bateman. Rand is a registered patent attorney with decades of experience protecting patents, trademarks, and copyrights for clients from startups to international companies. I'm Sean O'Connor, and today Rand and I are talking about common pitfalls in trademark registration and several unique issues that trademark applicants often overlook. Rand, how are you? Good to see you.
Doing well, Sean. How are you?
I'm doing great. I want to start right off with this question around certification mark. Like, what's a certification mark and how does it function differently from, say, a traditional trademark? I wasn't familiar with the delineation there.
Okay. So a typical trademark is used by one person or entity to identify the source of its goods. Certification marks do that in a little different way. So, for example, there's geographic marks that are certification marks. And so you can certify that this product comes from this region, right? So Idaho potatoes. There's a little logo that you can get that goes on your potatoes. It says, these potatoes were grown in Idaho. Okay, my dad's from Idaho. It's really important that they're Idaho potatoes. But you can have other things. One of the big disputes internationally has been some of the European countries are very particular about geographic marks.
Yeah.
Right. And so you can't sell champagne. You can sell sparkling wine unless you're from this particular region of France. You can't sell something like Parmesan if you're not from Parma, Italy.
Yeah.
Right. And so there's been a lot of fights with the US because, we call it Parmesan cheese. Right. And that's a particular cheese. We don't think of it where it emanated from. We think of it as a particular type of cheese. And so there's been disputes back and forth with that. But there are things that if a certain area has become well known for something, they want to be, this is from this region, and so you can get geographic marks. You can get quality material and manufacturing standards marks that such as USDA organic. Right. So this is certified organic. You qualify, you've met the test, your farm has passed all the tests that your goods are organic, or Energy Star. So this building component was made in such a way that it qualifies to energy standards required for Energy Star rating. Another really common one that you see a lot is a UL listing on a product.
Yeah, I feel like UL is like the granddaddy of them, like before we were even aware of this sort of stuff, UL approved or whatever was always a thing.
Yeah, so that meant that underwriters laboratories had tested your product and found that it met certain safety standards, and so you could use the UL listing. In a normal trademark, underwriters laboratory would put that on their products, but they don't really have products. They certify other people's products. And so that's a certification mark. And then the other type of certification mark can be work or labor standards. Are you a qualified electrician, right? So you may have some designation that says you're a qualified electrician. American Board of Urology, right? You're a doctor with this particular specialty. And so you can get certified by that. And that kind of brings us into the next type, which is a collective mark, which can be effectively the same thing, but it means you're a member of the association, right? So if you are a member of the association and you meet their standards for admission, then you can use that. And in a way, you could do it with a state bar, right? So Missouri State Bar or Utah State Bar or, whatever, that says I'm a member of that and I've met the admissions qualifications. So those are two different types of marks.
Mm-hmm.
They're not technically trademarks, but they're very, very similar. It's just who owns them and how they're applied. It's a little different.
So I wanted to mention, it seems like, because you mentioned the wine appellations and, Idaho potatoes. I spent a lot of time in Washington apples. There's a lot of major agriculture, right? Um, Huge trade associations and all that. And I feel like, if you buy any product in the grocery store these days, there are so many badges and seals. You mentioned organic, there's USDA. I know there was a lot of controversy around organic. What does it mean? What are the standards? What's the certifying body? And it takes a while to work these things out, but sometimes it's hard to know, right? Like, is this a made up organization?
Well, you want the really cutthroat ones is in eggs.
Oh,
Is it cage free? Is it free range? Is it, I mean, and the standards are sometimes are almost laughable. It's like, well, it's cage free. Well, why is it cage free? Because the chicken can stick its head out of a little hole and see daylight,
yeah.
right? And so some of those names, they don't really convey what a normal person would think, Okay, no, the chickens are running around, they're having a happy life. They're not stuck in a box
Right.
in a building. So yeah, that's pretty intense. Okay, so now we're going to get into trademarks and service marks. And this is an important thing. Everybody calls them trademarks now. It's very rare that you hear someone use the word service mark.
Mhm.
But technically they're different. A trademark is for selling a good, right? So it's something, a bottle of water, an apple, that's a trademark. If you're providing a service, if you're a restaurant, it's technically a service mark. And the only place that has any bearing anymore is how you show you're using it. And we'll talk about that a little bit.
Okay.
So in the first class where things get a little tricky is class 16. And that's for books and other publications. So you've come up with a book and you want to trademark the name. You can't.
You're publishing a trademark book, but you can't trademark the title of the book.
Yeah, I couldn't trademark Rand's Guide to Trademarks.
Got it.
Okay. But so here's a book. Okay, the title here, The Horn of Moran. Okay. Adventures Wanted is the top title. Okay, that can't be trademarked. It's a single work. But in class 16, if you have multiple works, you can get the trademark. So this Adventures Wanted, each of the book in the series is called Adventures Wanted and then as the name. So that Adventures Wanted can be trademarked because there's multiple, but there has to be a series. It can't be a single work. And the reason for that is, you have a title like Love Story. You don't want people getting sued over the title Love Story or something similar to it because there's a gazillion love stories, right?
Yeah. So it's just a common usage situation.
Yeah. And so to prevent anyone from owning that from a single work, then they can do, this one's got, two different titles, but it's a series. And there was one on here. Oh yeah. A Novel of Elfheim. Okay. So all of her works in this series have A Novel of Elfheim on them. So that she can trademark. Okay. So that's class 16. If you're doing if you do a newsletter or something, you need to have multiples with the same title and then you can protect it. So that's class 16. The other really big pitfall is class 25, which is clothing. Okay. The Patent and Trademark Office has this doctrine that they call ornamentation. And that's saying that a trademark needs to identify the goods, but it's not supposed to be the design of the shirt. So here's a shirt that I got. If you can see that. It says Honda across the front of it. If I were to try and register that for the shirt, I would get a refusal on ornamentation because their view is that Honda on there is not meant to identify the source. It's to ornament the shirt.
Right.
But I can get it. If you look closely, the label inside,
Sure,
that's proper trademark use. So even though that says Honda, can be the exact same design, I can get a trademark registration for that. Okay, so that's proper use. So the same shirt can be proper use and ornamentation.
interesting.
Okay. But a lot of times people will come up with a catchy phrase and they want to put it on a t-shirt and then they try and submit that for their specimen. And the patent and trademark office will say, no, that's ornamentation. And they go, what do I do? Well, what you do is you either put a tag like this on inside, or the easiest thing to do is a hang tag.
Yeah.
Like this. That's proper use.
Yeah. That's the Honda
So
logo.
if you want to do the big name on the shirt, that's fine. You print out a little piece of paper that has the name on it and use a nylon strap, put it on the shirt. Now you have proper use. You can get your trademark registration.
Yeah.
But
I'm thinking that tag is a sticker. Is that
yeah.
Honda? Is that a Honda sticker?
I think it is. Well, no, this is just
It's just shiny.
it just says, yeah, Honda official license product.
Yeah.
So those are two of the really common ones that people run into. The most common is class 25, but class 16 is common as well. Another problem with trademarks is if you have a computer generated specimen. So let's say you're selling nutritional supplements.
Okay.
And you send me a picture of a little bottle of your product that looks identical to what you're going to be selling, but it's not the actual bottle. It's a computer rendition of the bottle. That will get rejected by the Patent and Trademark Office. It has to be the actual bottle.
So am I sending the actual bottle, or am I sending a
No,
photograph?
it's a photograph.
Okay, so
yeah, this is the nice thing.
This has got to be common, right? I'm working with my graphic design team, my packaging team. They're sending me computer renderings of how it looks, and I'm like, oh, that's great. I'm going to give this to my attorney and get this registered while we're getting this product ready to launch.
This is how technology has made life way better. Because in the old days, we would literally take labels and mail them in.
Yeah.
And then you hope they didn't lose them, and it would take all this time. Now you just take a photograph of the product and away you go. Okay. But it has to be actual products. Now, remember we talked about services versus trademarks.
Right.
For a service mark, you don't have a photograph of the product, obviously, because there's no product. So what you show is you show advertising for those services. So if you're a restaurant, I have an ad for your restaurant that says we serve food, or or if it's a bar, we serve beer, whatever it is. Nowadays the best thing for IP attorneys is that we often just grab your website, because usually your website says what you do. And so I'll go in and I'll take a screenshot of your website. The important thing, though, is the trademark has to be closely associated with what you do, right? So if you're a restaurant, but we don't get to food until page 5 of your website, but your logo is on page 1, that's going to be problematic. But you just want it where it's, Denny's and then, All-American Breakfast or whatever. Then the examiner says, okay, yeah, that shows you're selling food. There's your mark. That's approved. When you use a website as a specimen, though, you have to identify where you got the image and the date you printed it down. So
essentially the actual URL address,
yeah,
date.
Yeah, so it's the easiest thing is when you make your specimen, just go in and copy the URL that you're on and the date, and then you submit that to the Patent and Trademark Office and it flies through. And it's so much easier than it used to be.
Yeah. Any other details about using websites for specimens? I mean, you mentioned making sure if it's food, that it's food from page 1. Are there any other issues there?
That's the biggest thing, is make sure that your trademark is close on where you're talking about your goods and services. It doesn't have to be page 1. You can have, the company name on page 1, and then on page 3, here's what we do. Just make sure you also have the company logo on that page.
Right. Yeah, usually the company logo would be ubiquitous, but not always. Right. And so, right.
Yeah, some people will just have it on the front page, put it on every page, just put it where, the about us or the here's what we do. And then it's closely associated, and then they approve it. So
got it.
Yeah, it's just specimens are one place where people get hung up a lot in getting their trademark registered. Just making sure they're using the name properly. If you've got a trademark that's valuable enough, make sure you use it properly. Another important thing is making sure that you're using your trademark as a trademark. Okay. You never use it as just a noun. if you're using a trademark, well, put the word brand behind it.
Oh,
Right. And then if it works, then you're using it properly. So, Kleenex brand facial tissue. You could say Kleenex facial tissue, blah, blah, blah. That's proper use. But you don't say, I grabbed a Kleenex.
yeah.
Because that's using it as the noun. And if it gets too much where you're using the noun, I've actually had cases where I've beaten the other side because they say, well, here's our trademark. And I'm pull up their website and they've used it just as a noun, right? They've used their trademark as the name of the thing 50 or 60 times on their website. And then it's like, well, then it's not a trademark.
Right.
Your product is just this. So
Well,
it's important that you use it properly.
It reminds me, and we're going to come up against time here, but and maybe this is a future episode, but this reminds me of, I mean, it's sort of part of the common culture in a sense. And you mentioned Kleenex, and escalator and some of these words that are, part of the, I'd say, common domain now, but were originally proprietary words, right? Escalator was a trademark at some point.
Yeah, trademark is a really funny thing because your trademark can become so powerful that you lose it. Right? When everybody starts calling the thing your trademark, you lose it. And so, for example, the copying company Xerox will run advertisements in business magazines every couple years, things that you can do with a Xerox. And it goes through all this stuff and it says, Xerox is not this, it's not this. Xerox is a brand of photocopiers, right? And they're doing that to avoid genericide. They're marked because it got to be the point in the 70s and 80s, right? You didn't make a photocopy, you made a Xerox.
Yeah, no, go make some Xeroxes.
Yeah, exactly. And that's called genericide. That's what happened to escalator. It's happened to a lot of linoleum used to be a trademark. Huh. And so, yeah, that's a good topic for another day. Sure. There's some fun examples of genericide.
I used to do some work in advertising where we had Naugahyde as a client. It was always Naugahyde brand vinyl coated fabrics, which was all about protecting. It was like a mouthful, right? But they were trying to make sure that this isn't just any pleather. This is Naugahyde brand.
That's great.
Well, Rand, we're out of time. Great talking to you as usual.
Well, thank you. It's been a pleasure to be here.
That's it for today's episode of Infringe at Your Own Risk. If you're preparing a trademark application, understanding these nuances can help avoid delays, refusals, and costly refilings. So connect with Rand and his team at the website batemanip.com. And as usual, don't forget to like, subscribe to the show, or leave a review if you found this episode helpful. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.